When the Second World War ended with its horrific brutalities and life-changing impacts, the victor nations faced another problem. What was to be done with the members of the Nazi Party and the Imperial Japanese governments who were responsible for the war and its many atrocities? They did have the power to arbitrarily execute them, but that would effectively obliterate the centuries of civilization which stretched between us and the summary slaying of the defeated in war. After all, the Nazis weren't being punished for opposing the Allies in the war, but for the inhumane acts of brutality that they committed in its course. The motivation for whatever action would be taken against them had to come from a desire to deliver justice to those who suffered unspeakable horrors at the hands of the war criminals. It couldn't just be a display of power of the Allied victors. It was decided that a series of trials before an international tribunal of judges would be held across the territories. It took place in the mid-1940s in Germany and eventually in Tokyo and other parts of Japan. The most famous of these were the trials of the high-ranking German officials at Nuremberg and the members of the Japanese High Command at Tokyo. In this video, we'll discuss the important legal questions that came up during these trials and rely on the perspectives offered by Justice Radha Binod Pal in this dissenting judgment at the Tokyo Tribunal. Right off the bat, there were issues with enforcing the law. Similar to the situation in Germany, those on trial in Tokyo were part of the former Japanese imperial government and the judges were all citizens of the victor state. So as you can imagine, this led to some apprehension that the accused wouldn't be fairly judged. And it was very important that the accused and the world watching knew that this trial was to be a fair one and not just a formality. Why? Well, because one of the primary principles of justice that any student of law will be taught in the first year of study is enshrined in the immortal words of Lord Hewart, Lord Chief Justice of England, that justice should not only be done, but should manifestly and undoubtedly be seen to be done. Meaning that the world should know that there was fairness and equity in the trial. So Justice Pal justified the tribunal on two grounds. The first, that each judge, although from a victor nation, is here in his personal capacity, each a distinguished jurist and not as a representative of his nation. And the second, that this isn't a trial where the loser nation in war is answerable to the victor nation, but a group of individual persons who have been put to trial before an international tribunal for the violation of the rules of war. Here, Justice Pal drew a difference between acts of the state, for which no individual could be punished, and acts of the individual, which would not be excused even if their position in the state government was high enough that their actions eventually became acts of the state. The next question before the tribunal was whether a war of aggression, which is a war whose purpose is to vanquish and conquer, was a crime under international law. The charter that established the tribunal and the trials defined wars of aggression as a crime, but the question remained. Was this tribunal supposed to follow the charter exactly and refuse to deviate from its text? Or was it supposed to rely on public international law as it had developed over the centuries? Here, let's take a quick moment to discuss a rather famous principle of law, the principle of non-retroactivity, which prescribes that if any law makes a certain act criminal, the same law cannot be used to punish people who have performed that act before the law was passed. So how can a charter that sets out to punish people for their acts in war validly punish those people who committed the crimes before the charter was even established? So, coming back to our question of whether the tribunal had to follow solely the text of the charter, or being an international tribunal, had to rely on existing international law in delivering his judgment. Justice Pal's view is that the charter did not criminalize these atrocities at all. He said instead that the charter couldn't possibly do anything but simply name the counts that the defendants stood accused of, and that the tribunal had to look into existing international law to determine whether the defendants would be guilty on these counts. The justice pointed out that the charter was drawn up by the victors in the war, and to think that the victors could ignore existing international law and by sheer might of their victory create new law and define new crimes to punish a defeated opponent in war is a grave violation of the principles of natural law. It is relevant to point out at this stage that during the trials at Nuremberg, Lord Justice Lawrence disagreed with this and claimed that the sovereign power of the defeated nation was now lost and in the hands of the victor. This meant that in Justice Lawrence's view, the victor nation could now write the law for the defeated nation and impose that law on it and its citizens. Certainly, this view is not sustainable. For example, had the Second World War ended with the Axis as victors and not the Allied, would international law automatically have been what Hitler would have it be? Would the savage acts committed by the Nazis be permitted in international law? It is unlawful to assume that a victor in war, due to sheer military might, has the right to make new law or to change existing law to suit their own needs. To determine whether aggressive war is or has ever been a crime, it helps to divide the chronology of events into 1. The phase preceding the First World War, 2. The phase following the beginning of the war up until the Pact of Paris in 1928, and 3. The phase that followed right after 1928 up until the Second World War. Prior to the First World War, any war described as aggressive or unjust had never been a crime. In many pre-war literary works, the right to declare war was available to every nation willing to wage that war, right from the destruction of Carthage by the Romans in 149 BC up to the colonial domination of Asia and Africa by Western European imperial powers. None of the conquests stood the test of a just war or one fought in self-defense, and yet the aggressors faced no legal repercussions. Following the First World War, many writers approached the question differently. Quincy Wright, in his 1925 work, The Outlawry of War, said that establishing responsibility for any aggressive war is difficult because war stems from natural causes more than individual actions. Senator Borah, speaking to the US Senate in 1927, proposed a resolution outlawing war as a means to settle international disputes. Hall, in the 8th edition of his work on international law in 1924, elaborated on the difficulty of establishing individual responsibility for aggressive war and said that international law is powerless to end war, suggesting instead that it must regulate the conduct of nations at war rather than seek to abolish it altogether. Many believe that the Pact of Paris was a turning point in this matter. In August 1928, the Kellogg-Briand Pact, or the Pact of Paris, was signed. Its preamble stated that it was time for the frank renunciation of war as an instrument of national policy. In the pact, the parties condemned the reliance of nations on war as a policy and agreed to settle all international disputes peacefully henceforth. Lord Wright writes that the Pact of Paris is the evidence of the acceptance by the civilized nations of the principle that war is an illegal thing. In Justice Paul's view, however, the Pact of Paris neither changed existing international law, nor did it make any new law in that field. Why? Well, after several attempts at such a declaration, the Pact of Paris finally came into being. Initially meant as a bilateral pact among France and the US, it was eventually opened up to the international community. Issues arose when Mr. Kellogg appeared before the US Senate, where he clarified two controversial aspects of that pact. The first, that wars started in self-defense were not illegal in the pact, and second, that every state was at discretion to decide when to exercise this right and how. There were no principles, no guidelines or directions in the Act to determine how to consider a war one of self-defense. Mr. Kellogg further clarified that no state could be held legally accountable for the misuse of this provision. The states would be answerable to public opinion only. The Pact of Paris came with many such conditions which lessened its credibility as an instrument of international law. For example, when the British government agreed to the pact only when it was assured that it would retain freedom of action in its colonies, and many other nations only acceded to the pact after it was clarified by Mr. Kellogg that the right to self-defense of a nation wasn't even limited to the sovereign territory of that nation. Simply put, a law by its nature is binding, independent of the will of the subject. The Pact of Paris, however, allows for nations to follow and ignore its provisions at will. What the judges were dealing with at Nuremberg is what Justice Paul considers the real reason why these trials ever took place, to penalize the crimes against humanity committed by the Nazis. Here we see a point on which Lord Wright and Justice Paul agree. Lord Wright wrote that the crimes of the Nazis were not limited to waging an aggressive war. They were waging a war with every intention to commit the brutalities they eventually would inflict. But after all, Justice Paul wasn't a judge at Nuremberg, he was one at Tokyo. He was to try the Japanese High Command for the waging of an aggressive war and not the Nazis for waging a war with inhumane intentions. Although the rest of the tribunal eventually ended up finding the Japanese High Command guilty and sentenced most of them to death, Justice Paul, for the various reasons discussed earlier and more, didn't agree with them. The questions don't end here. Does it matter that Hitler became the law of the land in Germany, while Japan continued to function constitutionally? If the Pact of Paris failed to criminalize aggressive war in positive law, does either natural law or customary law still make aggressive war a crime? Can anyone be held liable for a crime if he was performing a duty given to him by the state? And what if that state is a democracy? And therefore that crime, essentially the will of the people of that state, will an entire people be held liable? How can Western Europe cite humanity as a reason that aggressive war should be a crime when their own acts inside their colonies in Asia and Africa continue to be brutal and inhumane? One thing, however, is clear. The law grows and evolves with time. Within nations, the sovereignty of people is sacrificed to make them answerable to the state. But who is the state answerable to? As Mr. Trainin of the USSR put it, this is a field in which criminal law is only beginning to penetrate, where the understanding of crime is only beginning to take form.